We're going to talk about a few different types of patents. The first one that you probably are not familiar with is plant patents. Plant patents are invented or discovered and asexually reproduced, so not just breeding new different types of breeds of plants, but that creates a new distinct and variety of plants. So new variety called elephant garlic, really big, and these are all by Luther Burbank. He's kind of like the king of plant patents. He created 800 strains or varieties of plants. You'll see a peach here. What's special about this peach, you probably don't even realize. Most of us are too young to know, but peaches used to be more like nectarines and the pits would get stuck in them. They used to advertise peaches as cling-free peaches, so the flesh of the peach doesn't cling to the pit. It's really easy to just pop the pit right out. And then russet potatoes, all of our potatoes that are really big that you see at the restaurant, those come from him. Another type of patent is a design patent, and this is about what an object looks like. It's not about how it functions. So it's about ornamental characteristics, not functionality. So this is important in creating value that customers can associate with a particular type of company. So you just look at this bottle and you know that it's Coke. I thought it was interesting that Sony actually patented this wedge design for laptops. They're valuable for 14 years. The Statue of Liberty was actually given a design patent. What you're probably most familiar with are utility patents. So a utility patent, according to U.S. patent law, has to be useful, novel, non-obvious, legal, and practicable. We used to be a country where it was the first to invent. So if you kept records, if someone else patented, you could show that you had been invented it first. But now we're the first inventor to file. So you actually need to file your patent. And what I'm going to share with you today about utility patents might burst your bubble about the benefit of utility patent law. But let's first show some examples of patents. Every patent has a similar structure. So there's a front page. There's always a drawing on it. It always lists the title, the patent number, when the patent was issued, who the inventors were, who owns it, that's called the assignee, when it was filed. The difference between the filing date and the date of the patent is often around 2 years. So you can see here that this is a little bit over 2 years, from December 8th, 1997 to December 21st, 1999. But this can vary greatly. It can take a long time to get a patent. And then there's going to be information about classification codes. Other patents that are similar, these are used to kind of stake a claim of how different this patent is from similar patents, so this is important. Then there's an abstract describing this. You can see here from this, well, this is an Uncrustable. They call it a sealed crustless sandwich. It was by Menu Savers, which owns Smucker's. Then there's claims and drawing sheets. I'll show you a few more examples. A student in my class whose aunt got a patent. That patent was for a sponge that had the date on it. The idea was you're supposed to replace your sponge every month. In order to help you remember when to do that, she would put the month on the sponge and sell them as a 12-pack. Filed in 2010, received in late 2011, so about a year and a half. You think, well, that's kind of an interesting idea, but I don't know if I really need it. And that's one of the key takeaways that I want you to learn about patents is just because you have a patent doesn't mean that it's actually useful. It has to be useful. There's a patent examiner that examines the patent, and they may have a liberal or maybe a more conservative approach. They're the ones that decide, this looks like it fits. It could be useful, but that doesn't mean that it actually is. You can search for patents on Google Patents, so just patents.google.com. Here's an interesting example. This is an anti-eating face mask. You can see that basically you would put this on if you don't feel like you have control over your eating habits. You could just put this on so that you can't eat anymore. I use that as kind of a funny example because not all patents are actually useful or could be used to actually help you sell something. So just because you have a patent doesn't mean that there's a market for your idea. So this is a patent that was interesting to me because it was so valuable. So in some contexts, patents are very valuable. One of those is pharmaceuticals. So this is the patent for the drug that we more commonly know as Lipitor, which is for lowering your blood pressure. In the pharmaceutical industry, you have to have patents to protect your ability to make a drug that is easily reproducible after you figure it out and go through the testing process. So after a drug comes off patent, then others can start producing it, and then you see the price drop. If you can get generic drugs, that means that their patent has expired. They no longer have patent protection, and other people can copy it. In a patent, you need to specify or teach someone who's skilled in the art, so it's not just like teach your grandma, but someone that knows this area how to practice, make, or recreate the invention. So you actually have to tell people how to do what it might have taken you a long time to do. And you have to give technical background and other applications, provide a summary, and you have to have a detailed description. And then finally at the end, then you claim what your patent covers, the legal scope. And in exchange for doing this, so you're actually telling other people how to do what maybe took you a long time to do, you are given the nationwide right to exclude others from practicing the invention. This is very, very important wording. You have the right to exclude others from making, using, selling, offering to sell, or importing the invention. And you typically have that for 20 years. In some other applications, you can kind of extend that, but it's typically 20 years. And that is all given to you in exchange for complete disclosure. And we're not going to go into the background of why we have patent law this way, but basically it's designed to help promote innovation and also protect people so that they can share knowledge, but also benefit from the work that they've done. But again, I want you to get back to the right to exclude others. It's not the right to make, use, sell, offer, or import. It's the right to exclude others from doing that. So I'll give you an example here. This is Mason Jar Cocktail Shaker by W&P. They started selling in November 2012. They sold out in 3 weeks, and they had filed for a patent 6 months earlier. Doing really well, which is great. Then Home Essentials came out with another product that's quite similar called the original Mason Cocktail Shaker. They started selling that at the end of 2013 at Bed Bath & Beyond for $20. Looks kind of similar, right? So W&P, their attorneys send a letter in December 14th saying you're infringing on our intellectual property. And then Home Essentials responds, well, we don't actually think your product is patentable, and we're going to keep selling. So again, the original creator says, hey, you're infringing on our intellectual property. The imitator says, I don't think you can actually get a patent because you don't have one yet, and we're going to keep selling. You have the right to exclude if you have the patent, but you have to go to court to do that. So the average cost of doing these lawsuits is $1 million. And because of that, a lot of times small businesses can't really enforce their patent, even if they have one. To make it even more complicated, W&P had filed for the patent, but they actually didn't have the patent granted. They couldn't even go to court if they wanted to until they got the patent granted. So unfortunately, the story is often patents are not as helpful as you'd think they would be. Here's who's patenting. You can see that there's a lot of companies in the US, a lot in Japan, throughout the world that are patent, but these are big companies. Remember that the big companies are doing a lot of the patenting. Big companies benefit more from patenting because they can enforce it through lawsuits. Now, that doesn't mean big companies never get it wrong and they never lose in court. Occasionally this does happen. So Stack Electronics in 1993 sued Microsoft because they said that they were using their data compression technology, and they won $120 million. And then after that, Microsoft started making more patent applications. Priceline sued Expedia in 1999, and they ended up settling out of court. I just want you to remember, though, that all of this requires going to court. So does a patent need to be valuable? Nope, doesn't. Do you need to have a working model? Nope, you don't. You just have to describe how it would work. 10% don't actually work. Now, you'll hear some people say that you need to get a provisional patent, that's going to help you because provides protection for a year. It is often very useful to file to get a provisional patent, but that doesn't give you patent protection. It just is basically a filing placeholder. Basically, it says you're trying to tell the U.S. Patent and Trademark Office that you are going to file for a patent, and you're just trying to save your place in line to show that you're already in the process. But you don't have patent protection until they grant a patent. So if you file a provisional and then you end up never filing a patent, that was just kind of wasted money. If you file a provisional patent and you end up not being granted a patent, the provisional patent didn't do you any good. Ideas are not patented. That's kind of a loose area, but according to the law, it's any new and useful process, machine, manufacture, or composition of material, or an improvement thereof. So it's a little bit more than ideas. Does a patent give you the exclusive right to make, use, or sell the invention? Remember I said that it's not the right to do that, it's the right to exclude. And so the major takeaway from this is there are no patent police. You actually have to sue people in order to enforce your patent. You don't actually have to have made or used the invention to patent it. You just have to convince the patent examiner that it could be done. Can business methods be patented? Typically no, but occasionally it does happen, especially with more kind of technical methods. If you're in an area where you think that you might be creating something new, you should search at patents.google.com. And this can be really helpful because you can see what other people are doing. You can see other alternative approaches, see if companies are doing something in the area and are trying to patent, so that it's like giving a keep out sign saying, hey, don't work in this area because we may sue you for infringing on something that looks like our patent. Searching about patents might also help you to know, if you're doing something technical, who might want to buy or license your technology. Another piece of not so positive news is related to the lawsuits that have to be done in order to enforce patents. And there are organizations called patent assertion entities that we also call patent trolls. These are basically just a law office that's set up. They go around and they buy up patents from companies, say, hey, I'll buy your patent from you for some money, and then they go and sue other companies for infringing on that patent. And they may or may not actually be doing that. But typically who they're suing are companies that are smaller. So you can see here 66% of all defendants of cases by patent trolls, they have less than 100 million in annual revenue. And because it costs so much to defend yourself in court, you can see there 857,000 average in court or 340,000 average settling. These small companies just pay what the patent troll asks them to pay. It's kind of like extortion almost. But because they can make the lawsuit easier than the small business, a lot of times it works. So that's kind of the negative side of patents, is that often it's the bigger companies that win in a patent dispute because they can actually go to court and they won't run out of money trying to defend themselves. And it's big companies or patent trolls that end up having more leverage with patents. So patents are not always as useful to small companies, even though oftentimes you should patent to protect yourself because that's the only option that you have. It's not a perfect option because there are no patent police. You have to sue people to enforce your patent.